Members, we have a quorum and it is the appointed time. I call to order the fourth meeting of the Bills Committee on BHU Bill. Item 1, meeting with the administration. At the previous meeting, we were scrutinizing Schedule 4 under Clause 6. Two members want to ask questions, 4 minutes each. Reverend Peter Kuhn. Now about exemption number 6, a flag led by a non-profit making organization. So do they have to be non-profit making organization under Cap 88 or just any social organization? Now there are some organizations offering cheap housing to the youth with separate toilets and bathroom and a communal area. So do they count? Ms. Wong, if they have a standing under Section 88, that would be a clear evidence for their non-profit making status. Even without the Section 88 registration, we will see whether the organization meets the requirements under number 6. Dr. Wendy Hung, my question is very simple. Small houses or village houses in the new territories, how would they be dealt with? I think we have covered this question, but anyway, Mr. Chen, concerning village houses in new territories, they are not regulated by the bill. The premise of the regulatory regime is the existence of a building plan for the flats. And also the new building plans after the flat has been subdivided. For village houses in the new territories, there are no building plans because the requirement is exempted by the building department. Thank you. Any other questions on Clause 6 and Schedule 4? If not, let's move on with Clause 7. Mr. Chen. Thank you. Clause 7, determining domestic tenancies. The bill regulates residential tenancy or domestic tenancies, so we need to determine whether a tenancy falls within the definition. So we would refer to the written tenancy agreement to see the specified purpose. We will also look for evidence in the flags to determine whether it is domestic tenancies. Two members, Mr. Andrew Lam. Thank you, Chairman. Now, the bill also covers composite buildings, that is residential, commercial buildings. We have a large number of such composite buildings, whether on land lease or the building plan. Which part is residential and which part is for commercial is not specified clearly on the plans, because there is often interchanging uses or switching of uses between those portions. So how will you enforce the law on these buildings? Now, there are some businesses with no windows or ventilation for employees' dormitory. So how will you define these premises?
Ms. Wong, we will ask for the original building plan. So if it is a shop in front and residential at the back, it should be indicated on the building plan whether the part is for residential purpose or not. If the purpose is not for residential, then it will not be regulated. But if it is used for residential purpose, then it will be regulated. Mr. Lam, we have someone from the buildings department here. You have to vet previous plans very carefully. I have seen many cases where there is no indication whether it is for residential purpose or not in the original OP occupation permit. You must be aware of the situation. If it is indicated in all documents, that is fine. Ms. Wong. Thank you. We'll follow up with the buildings department later. As far as we know, most plans would have indicated the purpose. For cases where it is not, we will communicate with the buildings department as to the quantity of such plans and also the real situation. But as far as we know, most building plans will have indication of the purpose of the areas. So you are saying that most plans, but we cannot rule out that there are some plans without such indication, and you have to be clear as to how you identify the different purposes of the areas in the plan. Mr. Lam Chan Sing, for some composite buildings, they have subdivided units, maybe not for residential purpose, but for manicure services, for tutorial schools, etc. There aren't too many SDUs for residential use. You talked about specified and also the use now if it is for business purpose, but from time to time the occupant may stay overnight. Is that allowed? I just want to ensure that there is loophole. The tenant may claim that the SDU is for running tutorial classes when in fact it is for living in. Do you have provisions to guard against such abuses? Ms. Wong, the bill regulates residential buildings or composite buildings, the residential portion therein. If Mr. Lam is talking about the residential portion of a composite building, and if it is subdivided for renting purposes, for sure it will be regulated by this mechanism. But if we're talking about subdividing a residential portion and rent it out not for residential use, then it will not be regulated. If it is just for commercial use, then it cannot be used for inhabitation, and then the land grant terms are breached. It will be for another department to take enforcement action. We will not accept the recognition application for a BHU. So it depends on whether the location of the SDU can be for residential purpose. If the answer is yes and is rented out for residential purpose, then it will be regulated by this mechanism. Mr. Tony Jie, I'd like to ask about subsection 7, clause 7.2. If a tenancy specifies in writing that a SDU is to be let for a particular purpose, the subdivided unit is taken to be let for that purpose unless it is proved otherwise. What is the onus of proof? Is it for the administration to prove? Ms. Wong. Now, in the tenancy agreement, if it is specified that the space is for storage, and during enforcement action, we have found out that it is not for storage. Rather, we can see signs of inhabitation, then the enforcement agency has got proof to the contrary, and then can take enforcement action. That is the meaning of subsection 2. To put it simply, is it for the administration to prove that the purpose is not the one specified in writing. It is actually for a residential purpose. Yes, for all criminal matters, the burden of proof is on the government. Yes, we have to prove otherwise. Thank you. Legal advisor, thank you. In relation to clause 7(4), it is said that if there is not sufficient evidence showing that a subdivided unit was originally let for a particular purpose, the purpose for which the subdivided unit was let is to be determined by the primary user of the subdivided unit. That being the case, how do you define the primary use? And you talked about someone authorized by the Secretary for Housing. Will someone go into the SDU to inspect what is the primary use of the SDU? In deciding whether an SDU is a residential tenancy, we have to check, and if we gather evidence to show that it is actually for residential purpose, then it can be regulated. As I said, if it is claimed that the SDU for storage, but if it is found that someone is already living there with all the signs and evidence, then it will be regulated. It is considered SDU let for residential purpose. Any more point on clause 7? If not, can we go to part 2, clause 8? Yes, part 2, restriction on letting SDUs. There is only one clause under this part, clause 8, setting out the offense. Subclause 1 creates the offense of unauthorized letting of SDU. If 2 or more SDUs in a flat are let under separate domestic tenancies, while no grace period registration is enforced for the flat and no basic housing unit recognition is enforced for any one of the subdivided units. Subsection 2 creates the following offense. The persons who lets the unrecognized SDU under tenancy, or someone who lets the whole principal flat of the unrecognized subdivided unit, and a person not mentioned in paragraph A or B commits an offense, and a person who commits an offense under subsection 1 is liable on summary conviction to a fine at level 6 and to imprisonment for 2 years, and in the case of a continuing offense, to a further fine of 20,000 for each day during which the offense continues, or on conviction or indictment, a fine of $300,000 and imprisonment for 3 years, and $20,000 each day for a continuing offense. 4. It is a defense for a person charged with an offense under subsection 1 to establish that the person did not know and had no reason to suspect that the SDU were let in circumstances which constitute an offense under clause 8, and B, the person could not with reasonable diligence have prevented the SDU from being let in circumstances that would constitute an offense under clause 8. C, the tenancy for the unrecognized SDU for which person is responsible was not originally for habitation, and the person did not know and had no reason to suspect so, or the person could not with reasonable diligence have prevented the unrecognized SDU from being used for habitation. And for 6, the person is taken to establish a matter that needs to be established for defense under subsection 4 if there is sufficient evidence, and B, the contrary is not proved by the prosecution beyond reasonable doubt. That ends my introduction. Mr. Rincon, I've got a few questions. Under 8.1, if 2 or more subdivided units in a flat are let under separate domestic tenancies, why separate? Because I can use one domestic tenancy agreements to let 2 SDUs. So why separate domestic tenancies? 2B, a person who lets the whole principal flat of the unrecognized SDU. Now, there is a defense under subclause 4. It's talk about reasonable doubt or reasonable reason to suspect. Now, if I am an owner, if I let, for instance, an 800 square foot flat to a principal tenant, how can I query how come you have only one member in your family? Now, if the owner is really innocent, he had no reason, so what questions will we have to ask before he can invoke the defense under 4A and 4B? There is no way to prevent subletting. Now, if I sublet 600 square feet of 800 square foot flat to someone else, so why do we say separate domestic tenancies? We have to look at the facts. Let's say an owner has let his flat to tenant A, covering 3 bedrooms. So does tenant A uses all 3 rooms? If not, then he will then sublet one to another tenant. So there will be more than one tenancies. If the original owner has let a flat to a tenant in one tenancy, then he will not be regulated. But if tenant A becomes a principal tenant and he sublets all 3 rooms or 3 SDUs, then the principal tenant is in the business of SDU. Will the owner be held liable? Then it depends on first whether the owner has told the principal tenant that the flat is for the sole occupation of the tenant. He has already exercised due diligence. He has already told the tenant that the flat is not meant for further subletting. Then the owner can invoke the defense provided here. But an owner may be ill-intentioned. He wants to engage in an SDU business by letting his flat to a principal tenant, and he cannot be exonerated. Why do we talk about separate domestic tenancies? Because we don't want someone who has let his flat under one domestic tenancy to be caught. So if the owner has let his flat to one principal tenant in one single domestic tenancy, he's eligible for the defense. But if he has full knowledge that the principal tenant is going to sublet the SDUs therein, then he cannot be exempted. Mr. Rincon, well, I hope the naughty ones are not listening. So under 2B, if I'm a naughty owner, I will carve out the kitchen from the tenancy So you talk about the whole principal flat. So I just carve out the kitchen. You talked about a separate domestic tenancy. This is a big loophole because there can be more than one tenant, up to 3, under one single domestic tenancy. So if I am an owner, I let 3 SDUs to tenants A, B, and C. So you say that if there is only one domestic tenancy, then it will be caught. I think this is a big loophole. Yes, we have considered all the scenarios mentioned by Ms. Kuhn. For instance, can we carve out a certain space from a whole flat? For instance, in an 800 square foot flat, can only 600 square feet be let? Now we are talking about first the original plan of the flat. There has been subdivision or repartition. So there are 3 flats, 3 SDUs as a result. Now if they are let, I don't care whether the SDUs account for only 300 and 800 of the square of the flat. There are 3 compartments let for habitation. The whole flat is being regulated. And whether the requirement of a single domestic tenancy is a big loophole, the answer is no. If there are 3 SDUs in a flat, let under one domestic tenancy, that means there is only one tenant. That tenant has to pay for the rent of all 3 SDUs. Now, there are 2 SDUs with tenants and they pay rent to the principal tenant. There may be a verbal tenancy agreement already. So that is more than one domestic tenancies. So only one written domestic tenancy agreement cannot evade our regulation. If there are 3 SDUs and 3 strangers, will they be willing to enter into a tenancy agreement with the owner under one tenancy? This is because the 2 tenants whose names do not appear on the tenancy agreement will not be protected. And when the tenancy was first signed, the 3 tenants move in together. If in the course of the tenancy period, one tenant leaves, then the tenant whose name is on the agreement will have to bear the rent of the tenant who has left. And if that SDU is relet, then there will be another tenancy. That means there will be more than one as a result. So we believe our definition should be able to cater for all scenarios. That's very clear. Thank you. Mr. Kenneth Leung. Thank you, Chair. I'd like to talk about clause 4848. The person did not know and had no reason to suspect. The person, it could be that he did not know that recognition was required. He did not know that the SDU would be sublet. Will all these be part of the offense?
Well, not really. If the person didn't know that the SDO has to be recognized, well, that would not be accepted. Well, what it describes here means that a person who enters into a tenancy agreement clearly states that this premises will be let to you for habitation and you are not allowed to sublet it. Well, that means he has already tried his best to inform the tenants. However, after letting out the unit, the tenants could enjoy the use or he would have the exclusive possession of that unit. So the it will not be easy for the owner to enter that premises at any time he wishes. So if the tenants subdivide the unit and sublet the unit to other tenants, if the owner didn't know about the situation, then this could be his defense because he really didn't know. So if the owner says that he didn't know that the unit has to be recognized, this would not be accepted. Miss Starley. Chairman, you mentioned about 2 or more tenancy agreements. That's the condition. What about if some owners feel that he would need to enter into any tenancy agreements with any tenants? Would he be regulated? Well, the definition of tenancy agreement would include both written and verbal agreement. If they do not have a written tenancy agreement, however, if we investigate the objective facts, if there is actually an owner subdividing his premises and then sublet the units to other tenants, it could be through a verbal agreement. But then if every month this owner receives rents from the tenants, then that would actually be a kind of tenancy agreement, and they would fall under our regulation. Miss Lee, that means de facto. It's rented out de facto. Yes, that would fall under our regulation. So both the owner and his agent would be held liable. Yes. First of all, that unit has been subdivided. Well, what about if he doesn't alter the premises and there is no tenancy agreement? He just let the people live inside the premises without any tenancy agreement. Well, if that premises is sublet according to the original building plan, this would not fall under our regulation. Well, what if they are already existing SDUs that are below standard, and if the owner doesn't improve it or doesn't alter it according to your minimum requirement? Well, if the original building plan has been altered, that would be SDUs. And if the owner sublet or let the SDUs, be it on a written or verbal tenancy agreement, if he has 2 or more tenancy agreements, then he would be regulated by us. Thank you, Chair. Well, if there are some premises that do not have any building plan, for instance, a pre-war premises, and they do not apply for registration or recognition, is that an offense? Well, we have our definition here. We would work according to the original building plan. If there is no building plan, then that will not be under our regulatory regime. All right, Mr. Lam Chen Sing. Thank you, Chair. I have a question on clause 8(3). One is A is on summary conviction, B is on conviction on indictment. Well, I'd like to know about the threshold for conviction on indictment. Some are pretty high, and it is a rare chance that there would be conviction on indictment. I'd like to know the threshold here, or that you have in mind. Thank you, Chair. We have to look at the actual situation of the case. For summary conviction, it could be dealt with by the district court, and the fine is at level 6 and imprisonment for 2 years. So we believe that this is at a reasonable level. If in the future we find serious cases, we will then have them handled by conviction on indictment. The time might be longer, we have to really decide according to the situation of the individual cases. But in most cases, we will handle them on the route of summary conviction first. But again, we have to look at the case on a case-by-case basis. We can't say for sure which cases will be dealt with by summary conviction and which by conviction on indictment. Mr. Johnny Ng, I'd like to ask about the penalty as well. How do you decide on the level of the penalty regarding a fine of $300,000 and imprisonment for 3 years for conviction on indictment? These are relatively heavy. Well, say, for instance, the unauthorized building works, UBWs, at the market. Well, how do you compare those UBW offenses with these ones? Yes, we have drawn reference from relevant regulations, including bed space and accommodation ordinance, and also hostels and hotels ordinance, and so forth. Comparatively speaking, for the regulation of BHUs, we want to achieve deterrence purpose, so we've set the penalty level at a relatively high level, and a fine of $300,000 would be possible. And of course, this would have to be decided by the court eventually. We have actually drawn reference from other relevant ordinances to set this penalty level. Next, Mr. Andrew Lam. Thank you, Chair. Say, for instance, a unit has applied and then there are 12 bed spaces in a premises, but then 12 bed spaces are spread within 3 SDUs. Well, that would be governed under bed space and accommodation ordinance. Is that the case, Ms. Wong? Well, first we have to see whether that premises has been altered. We have to compare it with the original building plan. If it has already been altered into 3 SDUs, and if there are 3 separate tenancy agreements respectively for these 3 SDUs, this will fall under our regulation. Well, however, under the bed space apartment ordinance, there is a clear waiver or exclusion. If under that ordinance, if the owner has applied for license and it's become a legal bed space apartment, then it will not fall under our regulation. Well, if that is the case, frankly speaking, this is really a big loophole, if I may say. Well, people might choose an alternate route. We have to ensure that under that circumstance, that is, if the owner let the entire premises, well, for instance, he could put 3 to 4 bed spaces in 1 SDUs, then there will be 3 tenancy agreements, and let a family live in that premises. If that is the case, this premises would not be under your regulation. I have to make this clear. Well, we have to look at the actual situation of the case. For bed space apartment ordinance, we will have to see whether it should be tightened up. I got your point, Mr. Lam. We would try not to leave any loopholes between the ordinances. For BHWs, there is such a need in the market. As operator of the BHU, if he wants to make use of these loopholes, it would be quite troublesome or difficult for him, because the bed space apartment ordinance has its regulation as well. He has to make sure that his premises could meet with the requirement of the bed space apartment ordinance if he wants to choose this as an alternate route. Well, Ms. Wong, we just mentioned that in the future, in reviewing the bed space apartment ordinance, the administration will have to look at both ordinances, that is the bed space apartment ordinance and the BHU ordinance. I hope that you will keep that in mind in the future when these relevant ordinances are reviewed. Thank you. Next, Reverend Kuhn. Chair, we heard different cases just now. Will there be any mechanism for people to know straight away under what category their situation would become? Or yes, thank you, Reverend Kuhn. In the future, we will have a specific website on BHU, which will set out frequently asked questions and answers to them. There will be clarifications to different cases. We will also have an office or department responsible for answering people's questions regarding BHU regulation. We will also have a code of practice in place in the future, which will set out in greater detail about our minimum requirement for BHU recognition. So there will be ample routes and ample opportunities for people to seek clarification. Ms. Darily, Chairman, I am also concerned about the comparability of the penalties of different ordinances. Could you perhaps state in further detail about your rationale or consideration for these penalties? Ms. Wong. We have drawn reference from bed space apartment ordinance and also hostels and hotel and accommodation ordinance. For bed space apartment ordinance, the penalty level is $10,000 and imprisonment to up to 2 years. It's $100,000 fine and imprisonment of 2 years. There is also another route, that is conviction on indictment. That is, if the cases are more serious and the infringement is more serious, there will be a fine of $300,000 and imprisonment for 3 years. And for hotel and guest house ordinance, if it is on summary conviction, the fine is $200,000 and imprisonment for 2 years. And on indictment, the fine is $500,000 and imprisonment for 3 years. So from that, we could see that the penalty level under hotel and guest house ordinance are even heavier than our present one. The reason is that there would be more people that should fall under this category. That is, there are more people living in hotels and hostels, so that's why their penalty level is higher. They want to give more protection to a bigger group of people. But then for BHU, we believe that comparatively speaking, the people living in BHU would be much fewer. So our penalty level is, relatively speaking, lighter. Mr. Tony Sayer. Yes, Clause 8, Bracket 3, the penalty level. Some questions have already been asked, and the administration has made responses to them. They have drawn reference from other relevant ordinances, such as the bed space apartment ordinance and hotel and guest house ordinance. Well, do you have any precedent cases in the court? Is there any conviction level that we could draw reference from? Because for summary conviction, actually the fine level is not that low. Ms. Wong? Yes, we have studied the previous cases and the convictions. For bed space apartment ordinance, there are fines and penalty in recent years. Of course, they are not at the maximum level. We understand that the court will look at the evidences, and if there are cases, then the penalty would be higher. So what we've set out here is the highest level of penalty. Of course, eventually we have to rely on the court to make a decision on the fine level. We have, strong reference from the previous cases. Well, Chairman, what I'd like to know is if there is a great difference between what you set down here and the actual conviction by the court. Very often we have very serious penalty levels set out in the ordinance, but then in real life, in real cases, the court would just decide on a very low fine level. Would that be the case? I want to know. Ms. Wong? The administration, of course, would try our best to put forth all the evidences that we have collected to the court for consideration. But eventually, how the court or the judge would decide, it would have to decide on the judge. Would have to depend on the judge. Chairman? What about the recognition? You mentioned, Ms. Wong, that there will be a web page in the future. It will be open to the public and free of charge, right? Yes. For premises that have been recognized, we will put down in a list on our specific website for public reference. Ms. Doreen Kong. Chairman? Regarding penalty level, I have another question. In bracket 2C, as long as you are a person who is receiving rent, that means you are letting a kind of SDUs. Well, what about the banks or the money lenders? For bracket 2, especially C, if a person, whether he is in possession of the premises, as long as he is receiving rent regularly, if he does not apply for recognition of the unit, he would be against the law. But what about the bank or the money lenders? Would it be difficult for people to borrow money from the banks or the money lenders if that is the case? Ms. Wong. Well, in regulating the BHU situation, we want to make sure that owner of BHU would make an effort to make sure that their units are can meet with our minimum requirements and apply for recognition. Well, for banks or money lenders, they have to be more careful if our regulatory regime is in place. Well, for instance, if a bank, or after getting possession of a premises, they would look at the premises and see whether it is being sublet. And after being in possession of the premises, the bank would have to inform the existing tenant that when the tenancy agreement expires, the tenants have to move out because they have to improve on the premises so that it become a recognized BHU. Well, if the bank really didn't know that that premises is against the law, and if it cannot meet with our minimum requirement, well, as long as the bank could provide with evidence and ample reasons, we would consider whether this is a criminal offense or the bank really didn't know about the situation. We don't want to provide too much exclusions or waivers or gray area to avoid people making use of the loopholes.
Legal advisor. Thank you, Chairman. Concerning the statutory defense, the elements of due diligence is mentioned, and also diligence must be shown on the operator's part to prevent breaching the conditions. So how do you define reasonable excuse or defense? Ms. Wong? Concerning reasonable effort, we would consider the actual actions taken by the operators. As the signing of the tenancy agreement, if the operators have made it clear to the tenants that the tenancy is for the tenant's own residence rather than subletting, then we would consider it reasonable effort. But it also depends on the evidence. If it is clearly written on the contract that the flat should not be sublet, does it mean that reasonable effort has been made? Well, not necessarily so. There may be if there are evidence to the existence of oral agreements between the landlord and the tenants to ignore the provisions on the tenancy agreements, that would not constitute a reasonable effort. Any more questions on Clause 8? We are now at Clause 9. Mr. Chen. Thank you, Chairman. We are now at Part 3 of the bill, grace period registration of flags. There are 4 divisions and 7 clauses, 9 to 15. The purposes of the clauses are to provide a legal framework for the registration regime for pre-existing flags. Now we have supplemented some operational details in the paper. Now Clause 9, Division 1, registration of flags for permitting letting of certain pre-existing subdivided units during grace period. Under the division, there is only one clause, Clause 9. Secretary may register flags in which subdivided units were let for habitation during specified period. The clause sets out that on the Gazetted date or period, or during the period of 3 months ending on the Gazetted date, if in the flags there is a subdivided unit that was the subject of a domestic tenancy at any time, then subsection 2 applies to the flags. That is, the Secretary may, on application, register the flags for the purposes of the ordinance. The validity period is 36 months until the expiry of the is 36 months. Now, the Secretary may, by publishing a notice on the Gazette 6 months before the end of the grace period, extends the grace period. Dr. Starry Lee. Now, if a recognition is not obtained during the grace period, can the flags be let out? Now, the recognition process takes time. So how can you ensure that there will not be so much back and forth so that the period is extended beyond the expiry date? Ms. Wong, the registration of flags apply to the 110,000 pre-existing SDUs during the grace period. So between the 1st of March next year to the 28th of October 2027 or 2028, the 110,000 flags can be registered and enjoy a grace period between the 1st of March 2026 to the 28th of October 2028. So altogether, 48 months. If the SDUs are registered during the period, they will not be affected by our enforcement actions, even though they do not meet the requirements. the flags can still be let out. But we do encourage the landlord to conduct alteration works when the existing tenancy ends to ensure that the SDUs are up to the standard. So by the end of the grace period, the entire flag should be modified so that the SDUs are up to standard. So how can we prevent landlords from delaying the modification works? We have a countdown arrangement in the bill that is starting from the 30th month of the grace period. Even though the flag is registered and is eligible for the grace period, during the countdown period, if a tenant moves out, then a new tenancy agreement cannot be entered for that subdivided unit. So once the SDU is vacated, the landlord should conduct modification work and have the SDU recognized as a BHU, so that upon the expiry of the transitional period, the entire flat can be considered a BHU. Mr. Kenneth Leung. Thank you, Chairman. My question is also related to Clause 10. So point 4 under Clause 9, the power of the Secretary to extend the grace period by Gazetted. So will there have to be specified justifications for the Secretary to extend the grace period? How many times can the grace period be extended and for how long? Ms. Wong? Thank you. Subsection 4 provides for flexibility for the Secretary to review whether there is a necessity to extend the grace period. At this moment, we are confident that the 36-month-long grace period is sufficient. That is from the 1st of March 2026 to the 28th of October 2030. So altogether, 48 months' time for modification works. We believe that would be sufficient. Of course, in drafting the law, we have to prepare for contingencies. Towards the end of the grace period, from the perspectives of landlords and tenants, more time is needed for recognizing the SDUs, then the Secretary will have the power to extend the grace period. If that's the decision to be made, if that decision is made by the Secretary, we will consult the electrical and also consult the public to see whether there is a consensus that the grace period should be extended. At present, our position is firm. We believe that 48 months' time will be sufficient. Mr. Rin Kong. Thank you. Clause 9, subsection 1. If in fact there is a SDU that was subject of a domestic tenancy at any time during the period of 3 months ending on the Gazetted date, then it can apply. So just one SDU will suffice. However, the bill says that only tenancy in flags involving 2 or more SDUs would be subject to the regulatory regime. So should we specify that only when there are 2 SDUs in the flags, the provisions would be triggered? Otherwise, even if there is 1 SDU, the landlord must register it. Ms. Wong, let me explain the policy intent behind Clause 9.1. We want to apply the grace period to all 110,000 pre-existing SDUs, so the definition is flag-based. For example, if there are 4 SDUs in a 400 square feet large flat, we will not require the landlord to have a tenancy agreement for all 4 SDUs. As long as there is one tenancy agreement, it is eligible. At a particular point of time, if there is one tenancy agreement for any one of the 4 SDUs in the flags, then all 4 SDUs can enjoy the grace period. That's why we premise the registration for grace period on the basis of a flat. As long as there is one valid tenancy agreement in force, then the whole flat is eligible. In terms of the offense or the penalty, when there are 2 or more SDUs in the flat under independent tenancy agreements, they will be subject to the offense. If the SDUs are let out without recognition after the Gazetted date, so the policy intents are different here. Chairman, I think this is quite confusing to a lay person. Yes, if I am an old lady who has subdivided my flat into 2 rooms, but I am only letting one subdivided unit out to subsidize my living expense, according to this provision, she still needs to apply for a grace period. If I'm the landlord, if I'm just renting out one of my subdivided units for rent, do I still have to register for the grace period? Ms. Wong? The registration system is a voluntary system. If a landlord does not intend to rent out both SDUs, but rather keeping one for her use and just letting the other one out, then she does not have to register for it. Now, I said we would require only one tenancy agreement in place for the entire flat to be eligible for the grace period as a discretionary measure, because at a particular time, not all SDUs in the flat may be rented out. So as long as there is one tenancy agreement in force, the flat is eligible for registration. Mr. Vincent Zhang, thank you. Concerning Division 1 of Part 3, the grace period registration system. Now, the first year, starting from the 1st of March next year, will be key. I'm eager to see how many landlords are willing to register. Now, 3 years on after the tenancy control regime has been put in place, only 30,000 flats have been registered. So how confident are you that a lot of landlords will register for the grace period? So even though if there are 80,000 landlords registering, there are still 30,000 flats remaining for recognition. So in law enforcement, how will you treat these flats? There may be a lot of tenants living in these 30,000 flats. So in the first year after the regime has started, besides law enforcement, how can you incentivize landlords of SDU flats to register? Ms. Wong, I understand where the member is coming from. Now, registration for the BHU system is beneficial to the landlord. After registration, the landlord can enjoy a 36-month-long grace period. So up and until the 28th of December 2028, even though the requirements are not met, the landlord can still rent out his SDUs. So it's only natural that landlords should register for the grace period. Now, if the flats are not registered, law enforcement action will be taken upon the flats 1 year after the start of the grace period, and that would be an offense. So that is different from the situation of tenancy control regime under the AR2 form. So of course, as the government, we will enhance publicity and education to make the requirements known to more landlords and encourage them to register. We even have an early bird discount for early registered. If you register your flags in the first year, you can have the $3,000 registration fee waived. Mr. Andrew Lam, I want to confirm subsection 9(4). Now, will subsection 4 affect the length of the grace period, that is 36 months? Ms. Wong, subsections 3 and 4, if the Secretary is to extend the grace period, then first of all, the Secretary has to invoke the power conferred under subsection 4, and then the grace period of 36 months will start. Mr. Chen, now if the Secretary considers it necessary to extend the grace period before the end of the 36-month-long grace period, and also the countdown period, then the Secretary must make the decision and communicate it at least 6 months before the end of the grace period. Now, since the notice will be published on the Gazette, the notice has to be passed by Legislative under a negative vetting procedure. I think you're answering a simple question with a complicated answer. Now, if subsection 4 is invoked, that is subject to all the procedures, the Secretary decides to extend the grace period, no matter how long. It does not affect the initial 36-month grace period, but it will affect the total length of the grace period. Yes. Subsection 3 refers to a scenario where the grace period registration is the grace period is expiring on the 28th of December 2027. So the extension of the grace period means extending the length of the 36-month-long period. Extending the grace period means extending the 36-month-long period. Yes, the scenario mentioned by subsection 3 is that starting from the 1st of March 2026, there will be a 12-month-long registration period for the grace period. So between the 1st of March 2026 to the 28th of February 2027, that's the 12-month-long grace period. Immediately after the expiry of that grace period, or registration period for the grace period, the 36-month-long grace period will begin. So that's subsection 3. Subsection 4 means extending the 36-month-long grace period. So the power mentioned in subsection 4, that is extending the 36-month-long grace period, in subsection 5 we specify that there will be an announcement before the last 6 months of the grace period. That is because we have a countdown period, and we have to communicate the decision of the Secretary to the public before the start of the countdown period that we are going to extend the 36-month-long grace period.
May I ask a follow-up? Please do. So if the grace period is extended, will the other dates be extended correspondingly? Or what is your plan? Will you just extend the grace period, Ms. Wong? There are a few opportunities. there is a grace period registration, and that is 12 months. We may extend this. If the grace period registration period is extended, then the grace period will then be moved correspondingly. Still, it is a period of 36 months, but then there is also the possibility of extending this grace period. So both the grace period registration period as well as grace period may be extended. Having said so, we will consult the council first. I'd like to follow up on Mr. Andrew Lam and Mr. Vincent Zhang's question. Now, Mr. Zhang's worry is that people may not come forward for registration, and Mr. Lam's question is about whether the grace period can be extended. Now, it's good to have some flexibility, but then people tend to adopt a wait-and-see attitude. Now, if they hear the possibility of an extension, then they may adopt a wait-and-see spirit. So, as a result, will it be a incentive, or would be an incentive for people to delay registration? Well, there is both registration and recognition. There is a 12-month registration period for pre-existing SDUs. After registration, there can be a grace period of 36 months. For owners who want to register, the requirement is very simple. The address of the flat, the name of the owner, the number of SDUs. That's all the information we require. There is also a registration fee of $750. There is a total waiver during the 12-month grace period registration. So we are quite confident that for registration of existing SDUs, most owners will have the incentive to register. For recognition, the requirements are a bit more stringent. The minimum standards have to be fulfilled, as well as some other requirements before an SDU flat can be recognized. That's why we allow 48 months for owners to address all the issues related to recognition. It is quite unlikely that owners will wait until the very last minute because we provide a 6-month countdown period. Because during that 6 period, a registered SDU cannot enter into new tenancy agreements if it is not recognized. So we have taken various measures to encourage early registration as well as recognition. Ms. Starry Lee. So the registration and recognition system as well as the countdown system are quite well planned. What is the manpower projection for carrying out the tasks? Because the workload is quite substantial. We have a task force within the Housing Bureau to do that, and the registration is relatively simple. We will have a dedicated website. Owners can submit their registration online or in writing. Colleagues will only check whether documents have been all provided, and recognition is a bit more stringent, and therefore we need an audit report from a professional. Owners who seek recognition of BHUs must submit an audit report by a professional. We trust that professionals have checked that minimum requirements are met, and the department is not going to vet each and every case. We will only conduct random checking. We will rely on the professional's audit report. A follow-up, I'd like to know whether you have any estimated manpower demand, and what about inspection? Will you take the initiative to take enforcement action? Yes, we still rely on a task force within the Housing Bureau, and we are internally redeploying resources. During the first year registration period, that is not the peak demand for manpower. Starting from 2027, when we start to take enforcement action, we will do random checking of cases, but we're not going to cover all cases. Enforcement will be risk-based depending on the condition of the buildings concerned and whether there are many SDUs or BHUs in that particular area. Legal advisor. In 9.4, it is said that the Secretary may, by notice published in the Gazette, extend the grace period. I'd like to know whether extension can only be for one time. Can it be more than one? Ms. Wong. We have not specified in the legislation the number of extensions, but then extension of the grace period is a solemn matter. We will not extend the grace period innumerously. We will consult the Council to see whether there is the need to extend the grace period. Our position is to improve the condition of SDUs as soon as possible. Over a 12-month registration period and 36 months grace period, we believe that will be sufficient time for owners to improve the conditions of SDUs. Thank you. Division 2, application for grace period registration. We have clauses 10 to 13. Clause 10 is application for grace period registration and the details. The application must be made by the owner of the flat or by a person with the written consent of the owner, and it must be made within the 12-month period beginning from the 1st of March 2026, and the Secretary may, by notice published in the Gazette, extend the grace period application period. We have set out in Schedule 2 fees to be waived. There will be a full waiver of fees during the 12-month period. Please pause after Clause 10. Any questions in relation to Clause 10? No. Clause 11. Thank you, Chair. Clause 11. Determining application. In determining a grace period registration application, the Secretary may take into account the following matters: documents or information provided, any document or information provided for compliance with a requirement imposed under Section 36(2) and the findings of any inspection. Subsection 2, the Secretary may refuse the application if the application does not comply with certain provisions and a requirement imposed under Section 36(2) for the application is not complied with, or an authorized officer's request for entry is refused, or if the Secretary is satisfied that there is an imminent danger or risk to life or property, and the Secretary may also refuse an application under any other reasons. For instance, if the flat has been used by the owner for illegal purposes. Mr. Tony Jie. With regard to Clause 11, it gives the secretary or government officers more powers. I have no objection to that. However, for 11(2)(d)(3), the flat should not be registered should not be registered for any other reason. Would it be better drafted if we say if the secretary is satisfied that there are reasonable reasons for refusing the application? Ms. Wong, as explained by my colleague, this is a catch-all phrase. For instance, if the flat is being used for some illegal purpose, such as a casino or a drug manufacturing, a DD manufacturing place, then there can be reasons for refusing the application. But we understood the member's point. Can we provide a further breakdown of reasonable reasons for not accepting the application? We'll take reference from other pieces of legislation and come back to members. Now for Clause 18 and 25, there are similar situations. Can you please consider them all together? Thank you. Mr. Lam Chanxing. Subsection 2(d)(2). There may be an imminent danger or risk to life or property in the flat or the common parts of the principal building, and application can be refused. I think you're talking about a serious situation. Can you give us some examples to illustrate this point? To let the public know that for buildings with this problem, the owner may as well give up applying because there is no way the government will approve it. Ms. Wong, now we are talking about really building with very real risks. Perhaps the buildings authority have already issued an order stating that the building is not fit for habitation. So even if the flat itself has fulfilled our requirements, we will not approve such an application. It is quite likely that orders have been issued by other departments. Ms. Doreen Kwong. For cases under D2, will the relevant records be available for public inspection? Because as said by Ms. Wong, you will be talking about really dangerous cases. I hope the records can be accessible by the public so that people know how the buildings pose imminent danger or risk to life or property. As said by Mr. Tony Jie, 2D will appear again in the provisions covering recognition. Now, when you consider D2 and 3, I'd like to know whether the same yardstick would be used, whether the same standard would be used in registration and recognition. Now, if there is an imminent danger or risk to life or property in a certain building, I'm sure the buildings department would have already made known to make this known to the public. If we're talking about the same provisions, then the same yardstick should be used in enforcement. Mr. Rincon. Now we're talking about a whole building. If a whole building is risky, will you let the public know? It depends on the facts. If a building is not fit for human habitation, the public should have been made known. But if it is our decision that a certain case should not be approved, we will not make public the details. But for registered and recognized SDUs or PHUs, the list will be on our website. So people who are planning to move in BHU, they can check against our checklist so they know whether the BHU is recognized or registered. Mr. Andrew Lam. Whether there is any danger or risk in a certain building. Now perhaps there is already an order stating that a building is dangerous. I'm sure you will not allow an SDU in that building to be recognized. But my concern is a risk or danger that only emerge after recognition or registration. In that case, how will you deal with the situation? Absolutely. Maybe after recognition or registration, the SDU or the building itself has come up with some danger or risk, then we will issue a notice to cancel the registration or recognition. But that decision will not be taken lightly. After all, will be affecting the sitting tenants. So when the Secretary exercises that power, he will consider the objective facts, but there are cases where the registration or recognition may have to be cancelled due to new situations. Ms. Andrew Lam. The Housing Bureau or the Housing Department must liaise closely with the Buildings Department because a temporary closure order may be issued. Whether you have to cancel the registration should be considered very carefully, and I hope you can have internal guidelines as well. Yes, the Buildings Department has assisted us in drafting the bill, and we will set up a communication channel in the future. Any more questions on Clause 11? If not, Ms. Doreen Kong. Oh, I'll wait until Clause 13. All right, Clause 12. Mr. Chen. Thank you. Clause 12 and Clause 13 are relatively straightforward. Application approved and application refused. No matter whether the Secretary approves or refuses a registration, there must be written notice to the applicant, and there must be reasons stated. Ms. Doreen Kong. Thank you. When an application is refused, there is no compensation mechanism for the tenants. But in Division 3, cancellation of registration, you have compensation mechanism. Why the difference?
Ms. Wong, thank you, Chair. Yes, there are differences between the two. For the present clause, it's about the application for grace period. That is the 110,000 SDUs applying for a grace period. We require certain documents, not much, but if that application is refused, that means the building or the unit might be in danger. It's not fit for habitation. But then there will be no compensation for the tenant. But however, when the registration is cancelled, that is, the unit has been registered or recognized, but then for some reason the recognition or registration has been cancelled. In that case, the tenants would receive compensation. The responsibility would be in the hands of the owner. So the owner must compensate the tenants for that situation, because under that situation, recognition has been granted, but then there are some other conditions arising, then the recognition is cancelled. Then it would be the owner's responsibility to compensate the tenant. Ms. Kong, I think the difference is too subtle. If, for instance, the owner has made an application, the unit is already registered, it might be 1 or 2 months after he has made the registration. And in that case, he would be held liable. He has to compensate the tenant. I think that is not desirable. Well, if the kind of new situation is not caused by the owner, for instance, if it's by force majeure, if it's by natural disasters, for instance, then the responsibility should not lie in the hands of the owner. I think this should be set out more clearly. Yes, Chairman. Let me perhaps go through the flow between application, registration, or cancellation of registration. For instance, an owner applied for registration, a grace period is granted, and theoretically the owner will have a total of 48 months to make a modification to his SDUs. But in the meantime, if for certain reasons the registration has to be cancelled, well, for instance, if the owner is responsible for such situation, then there will be then the secretary would issue a cancellation of the registration. Then the tenancy would be compensated. But if that change or the situation is not caused by the owner, then the cancellation of tenancies would not be issued by the Secretary for Housing. So this is not automatic. It doesn't mean that when the registration is cancelled, then the tenancy would have to be terminated. No, that is not the case. The secretary would look at the situation and then decide which step to take. Well, Chairman, I would be very worried then. In Clause 14, there is no mention about the changes not caused by the owner. So I hope that administration would go back and reconsider Clause 14. All right, we will go into that in further detail when we come to Clause 14. Mr. Andrew Lam. Thank you, Chair. Just now, Ms. Wong has explained very clearly. For the registration, the documents or evidence required would be minimal. Well, at that stage, I think that we should set some deadline for whether an application would be approved or rejected or refused. I hope that you will go back and consider how long that period should be, because you just mentioned that the documents required will be minimal. So I think you should set a kind of deadline for the approval or refusal of application. Thank you, Chair. Ms. Wong? Thank you, Chair. Yes, we have taken note of your view. For application of grace period, the documents required will be minimum. Well, after collecting all the necessary evidence, we hope that within 15 days after receiving those evidence, we will be able to issue a result. for a recognition application, we will have to draw reference from similar applications from different departments. We will have a service pledge in due course, but then these may not be written down in the regulation. But please rest assured that we will let members of the public know about the time required or our service pledge. Any further question on clause 12 and 13? If not, clause 14. Mr. Chen, please. Thank you, Chair. Division 3, cancellation of grace period registration. There's only one clause, which is clause 14. The Secretary may cancel grace period registration. So under certain circumstances, the Secretary may cancel a registration. Well, that include, for instance, documents are not provided sufficiently, or if the flat has an imminent danger or risk to life or property. We also have a catch-all phrase here so that the Secretary could cancel the registration for any other reason. For instance, if the SDU is used for illegal purposes, and the cancellation or notice of cancellation there will be a specified period for this notice to be issued, and the owner will have no less than 30 days. That is, the cancellation date must not fall within the period of 30 days beginning immediately after the date of the cancellation notice. And the notice will be put up in the SDU's front door, and the tenant could, in accordance with Part 7, recover as a civil debt compensation from the operator of the SDU for the termination of the tenancy. Mr. Tony Tse. Thank you, Chair. Well, we have talked about the phrase "for any other reason." I will not go further here. For subsection 3B 1, that is the subdivided units of whom the Secretary is aware. Well, this is about serving of the notice. So that means the Secretary notice has to be served, but then how can we make sure that the notice has been received by the operator? And if the notice is served, that means the tenancy agreement would expire and the tenants have to move out. Well, serving of the notice, that means the notice has been sent. In doing registration, we would apply the applicant to provide his address, the mailing address. We will then send the notice to the operator according to the address. And for the tenants, information will not appear on the registration. So the notice has to be put up on the main door or entrance to the flat or to each of the SDU so that the tenant would know about this. And whether the tenancy agreement would expire on that situation, we will have to consider the case on an individual basis. The Secretary has the right to issue the notice to terminate the tenancy agreement. But normally speaking, the cancellation date must not fall within the period of 30 days beginning immediately after the date of the cancellation notice. The reason for that is because we want to provide time for the tenant to make arrangements to move out of the premises in question. If the tenant require more time, we would have a social work team to assist these tenant. But in any case, the SDU's tenancy agreement has been cancelled, so the tenant should not stay on for any longer time. Yes, of course, we hope that we would be able to assist the tenant because the tenant has to move out of the flat. And this is the case when the registration is cancelled. I hope that the administration would provide more assistance to such tenants. Mr. Andrew Lam. Thank you, Chair. On the one hand, this clause has some relation to the landlord and tenants consolidated ordinance. And the Secretary for Housing could make a decision to issue notice to terminate the tenancy agreement in question, or to cancel the registration in question. Well, according to the landlord and tenants ordinance, then the tenant should be protected under the 2+2 rules. That is 2 leases in a row. Well, in this case, the owner has to make a decision, that is to ask the tenants to move out, not according to his own wish. It's because of some problem arising to his registration or recognition. In subsection 5, it says that the tenant could recover as a civil debt compensation from the operator of the SDU. But is the landlord really liable? Because the situation is not caused by the owner, it's a cancellation of the registration by the administration. Will the administration take action according to the landlord and tenants ordinance, because the tenants should be protected under the 2+2 leases arrangement? I'd like to seek clarification on this point first. Ms. Wong. Thank you, Chair. Section 7 of Landlord and Tenants Ordinance sets out the responsibilities of the landlords and the protection given to the tenants. All these will be valid. They will still be valid, and they will not be affected by the new BHU regulation. For 2+2 protection, under the Rating and Valuation Department, they will continue to make enforcement actions. For instance, if the Housing Department finds the premises in danger or not suitable for habitation, then the 2+2 protection clause will not be valid anymore. So, under our regulatory regime, for BHU, registered subdivided units, after being registered, the owners will have the responsibility to make sure that these SDUs are safe and suitable for habitation. But then, after inspection, if we find that these SDUs are not suitable for habitation, the registration will be cancelled, and then the tenancy agreement will have to be terminated. will the Secretary for Housing then issue a notice to immediately terminate the tenancy agreement? This may not be the case. Well, we may leave some time for the landlord to communicate with the tenants to let them know that this is not suitable for habitation anymore and they have to move out ASAP. We will also have social work team to assist them for moving out. Cap 7 protection will still be valid. To follow up, I think Ms. Kong is quite familiar with this. If the owner is forced to terminate the tenancy agreement, then under Landlord and Tenants Ordinance, I don't know what sort of protection will be provided to the tenants under that situation. I'm not sure about this yet. Ms. Kong? Chairman, Clause 14, subsection 5, it's very short, but I really hope that the administration could clarify some areas here, some points here. Like if the tenant has not paid up the rent, would the owner still have to compensate the tenants if the tenants has to move out under this situation? And before cancellation of registration, will the rights and obligations of the owners and the tenants be protected? And also, if the situation is caused by natural disasters, not by the owner himself, then it is quite difficult to decide, well, is it caused by the owner or caused by the natural disaster? What about if the cancellation is caused by any other fault on the tenant's part? What would happen then? And subsection 5 mentions about tenants. I know that there are the subtenants would also be included, but then for the subdivided or those who are not the principal tenants, who should they go after for compensation? Well, another point is related to the point raised by Mr. Andrew Lam. Under Cap 127, 1208AZI, and 120AAZI doesn't cover the situation that we mentioned here. In other words, if the owner terminates the tenancy agreement, then he may violate Chapter 7 of 120AAZI. So I'd like to hear explanation or clarifications from the administration. Ms. Wong? Thank you, Chair. There are a number of questions here. First of all, in termination of tenancy agreement, and if the tenant has not paid up his rents, what should be done? Then subsection 5 here mentions about civil debt compensation. That means the tenant has to make an application to the Small Claims Tribunal. And in the Small Claims Tribunal, I believe that the judge will make a decision then. And when a tenancy agreement is terminated, and if it is terminated because of the fault on the part of the tenants, will he still be compensated? Well, we have to look at the real case situation. The responsibility will lie on the person who submitted the application for registration. In other words, the owners or the landlord. For tenants and subtenants, who should they go after for compensation? Well, the subtenants would go after the principal tenant for compensation. And for the principal tenant, he would go after the owner. For Cap 7, I would like to ask Mr. Chen to supplement.
都想澄清翻一點咧，即係而家喺嗰個業主租客條例之下咧，咁係嘅有個2+2嘅租住權保障嘅。咁呢個咧係以一個合約嗰個嘅條文方式就顯現出嚟啦。咁所以就係話其實咧，當年去訂立呢個業主租約條例嘅時候咧，都討論嘅時候咧，都有同立法會交代過咧，就係話即係呢個條文咧去行使咧，其實就唔會咧係凌駕於咧即係政府部門咧係按其他法例咧嘅執法行動嘅。咁有個例子啦，就譬如話，如果因為喺業主租客條例之下咧，其實工廈嘅劏房都可以做出呢個登記㗎嘛。咁佢登記咗之後，就即係會有呢個2+2嘅呢個保障權啦。但係其實若果即係屋宇署去執法嘅行動嘅時候咧，其實呢個租住權咧都已經係即係不能夠保障㗎啦。因為某程度上，因為已經其他部門走去做執法嘅時候咧，咁就變咗係會有個即係安置嗰個嘅考慮啦。咁所以就差唔多嘅情況啦，就係話日後若果簡破房之下咧，我哋真係有一啲情況係取消咗嘅話咧，其實即係2+2呢個租住權咧，就會喺我哋安置嗰度咧，去幫嗰啲居民咧去揾翻一個居所咁樣。
江議員繼續啊。
主席，唔好意思，我真係想問清楚啫。其實你都冇答我一個問題。咁即係話，如果佢因為取消咗呢個登記，咁即係佢會唔會違反咗頭先我所講嘅120AA2ZI？會定唔會呢？其實好簡單，你唔好用工廈嚟到做一個比喻，我就用翻住宅啫。咁會定唔會呢？
係咪請阿陳生回應？
呢個我哋會後再補充。
OK， 唔該。
好。14條仲有冇提問？如果林筱魯議員。
主席，我呢個唔係提問嚟嘅，我只係一個分享我嘅擔心呢，就係你有好大嘅機會製造咗一批嘅苦主出嚟，唔好理佢多與少。嗱，我明白個條例上面佢哋有權做民事訴訟，小額錢債申索，完全明白，你冇做錯嘢嘅呢度。不過現實環境你要記住，住喺劏房嗰紮街坊，連租。
But in reality, the tenants who live in SDUs have trouble paying the rent. So how likely is it that they can file a civil debt claim to the small claim tribunal? So I surely hope that there will not be a large number of victimized tenants. Ms. Wong? Thank you. About the civil debt claim, that's a likelihood. Now, for those SDUs which have their registration or recognition cancelled, we hope that the tenants would move out as soon as possible. So that's why there is a cessation arrangement. And also, there is a likelihood that the landlord has to compensate the rents paid by the tenants. The welfare of tenants in the SDUs are our utmost concern. We understand that not every tenant in SDU may file for a claim, but the point is the tenancy agreement has to be terminated, and subject to the termination of the agreement, a claim can be made by the tenant. Clause 15. Thank you. Division 4, Supplementary Provisions. Clause 15. Notification of certain changes. To ensure that the Secretary for Housing can reach out to the operator or owner of the SDUs, if there are any changes in the particulars of the responsible person for the registered flat, they must notify the Secretary of the change within 15 days of the change. As long as one of them has notified the Secretary, the requirements will be fulfilled. If anyone failed to comply with the notification requirements without any reasonable excuse, that would be an offense, and subject to a fine of $25,000 and $700 for every day during which the offense continues. Now, we have based the penalty level on the Companies Registry Ordinance concerning similar offenses. Mr. Tony J. Just a brief clarification. When we come to clause 27, there is also a notification requirement for changes in particulars of the BHU. So if there are changes in the layout during the grace period, notification is not required, because registered professionals auditing is required before a report is made. Now, after the audits by professionals and before the acceptance of the reports by the Secretary, if there are any more changes, are those changes required to be reported? Ms. Wong, that refers to application during the grace period. That is for the pre-existing 110,000 SDUs. Upon registration, they will have 36 months time plus 12 months time for applying for a recognition. During that period, the landlord will have sufficient time to prepare an audit report and other requirements. So we are talking about application during the grace period. So I think Mr. Chair's question is more relevant to new SDUs and their recognition. For pre-existing SDUs, after registration, they can engage an authorized person to prepare an audit report for them to get a recognition. So even without a recognition, during the grace period, registered SDUs are still considered safe and lawful. My question is, after a report is made by the registered professionals, but then there are alterations during the grace period before the Secretary has recognized the SDU, is the landlord required to notify the authority with about those changes? Ms. Wong? So I think the case is a professional has been engaged to compile an audit report for a registered SDU. So with the audit report, an application for recognition is made to the Housing Bureau. So at that stage, we will consider the report and approve a recognition if everything is sound and safe. Then the SDU would become a recognized SDU. It will be valid for 5 years. So during that 5-year period, Chair, I mean that after the preparation of an audit report, it will still take time for the administration to consider the application. So in that interim, will any changes be required to be reported? So I think the administration need to conduct a would not conduct a site expansion. You would just make a judgment based on the audit report. So there is a gap in between. If there are any more alterations during that period, does the landlord have to report the changes to the Secretary? Let me try to understand the question. After the compilation of an audit report, say in February, that is completed, then the applicant submitted an application in April. So say in March, if there is a change, what should be done? So the major responsibility holder of the application is the SDU's operator. If there are more alteration works done in March, rendering is a significant change in the audit report's contents, then the responsibility is not with the professional, but with the applicant. On submitting the application for recognition, they have the responsibility to ensure that the information submitted reflects the actual situation in the flat. So the responsibility lies with the landlord. Concerning the professional's responsibility, the report would be dated. So the responsibility of the professional would end there. In short, if there are any more changes in the interim period, the applicant needs to notify the authority of the changes, because the landlord does not know whether that constitutes a significant change. That has to be decided by the authority. Thank you. Mr. Andrew Lam, will your question be long? If it is long, let's wait for tomorrow. Please be brief. Thank you. I have a question about an exceptional scenario. In terms of property transaction, some properties may be sold without the tenancy agreement, but the handover time will be set further down the road. So there is a change in the ownership, but the operator is still the same. So for these scenarios, if there is an enforcement action leading to penalty, how will the responsibility be assigned? So I know that the court will make a decision, but what is the government's position on the main responsibility holder? Ms. Wong, we have to go back to the definition of the operator. So they may be the owner of the property or someone who has the right to receive rents arising from the flat from time to time. They would be regulated by the bill as well. Mr. Lam? I think I understand. So that's the end of the scrutiny for clause 15. Item 2 on the agenda, AOB. Now, because of the typhoon, I said that if there is no meeting today, we would have a meeting on Wednesday. But since we have held two sessions of meeting today, so according to the last arrangement, we will cancel the meeting at 8:30 on Wednesday, unless you are so inclined. So if there's no objection, the meeting on Wednesday is cancelled. Now the 5th and the 6th meetings will be held at 8:30 a.m. and 10:45 a.m. tomorrow. There being no other business, the meeting is adjourned. Thank you.